Nowadays, someone who buys a new car can expect a pretty decent extended warranty covering parts. That wasn't always the case. In Henningsen v. Bloomfield Motors, the Supreme Court of New Jersey confronted a car that fell apart and a manufacturer that didn't want to cover the damage. Claus Henningsen wanted to buy his wife Helen a car for Mother's Day. Claus and Helen visited Bloomfield Motors, a Chrysler dealer, and selected a 1955 Plymouth Club Sedan. Claus executed the purchase order, which was a printed form 1 page long. The type got gradually smaller as it went down the page until it finished with 2 paragraphs of extremely small 6-point type. The paragraphs in the tiniest print on the front page stated that the front and back of the order comprised the entire agreement. The back of the document contained another small print paragraph stating that no express or implied warranties were made on the vehicle. Chrysler's liability would be limited to replacement of defective parts, and that would happen only if a defective part was sent to the factory for examination and the manufacturer agreed that the part was defective. Claus didn't read these paragraphs, nor did Bloomfield call them to his attention. 10 days after Claus purchased the car, Helen was driving at about 20 miles per hour. Suddenly, she heard a loud crack from under the car, the steering wheel jerked in her hands, and she spun off the road and crashed into a brick wall. The car was totaled. The insurance inspector suggested that something was wrong with the steering wheel and that the accident was likely due to mechanical defect or failure. The car was so damaged, however, it was impossible to know for sure. The Henningsens sued, claiming that Bloomfield and Chrysler had breached express and implied warranties. The trial court found for the Henningsens. Bloomfield and Chrysler appealed to the Supreme Court of New Jersey.